Okay, so it is just about 12:05 now, and welcome everyone to part 5 of our 6-part webinar series that we've been doing this spring during the pandemic. Uh, my name is Brad Batcha. I'm an attorney here in Shrewsbury, New Jersey, and we do all real estate law here, a lot of real estate closings. And today we are going to talk about the New Jersey Realtor Form contract. That's a great form. Obviously, almost all the realtors, I believe, now use it. It's funny, years ago, a lot of the different agencies would have their own proprietary form, but more and more I see everyone tend to be using the NJ Realtor form. And I tell you what, it gets updated quite often with a lot of good changes. So I think it's the wise move to use that particular form. Um, One of the reasons I thought to bring this up as a topic for our webinar series is that there have been so many recent changes. I originally had done a program in the spring, and that was to address 2 additional forms that were added in October. But since then, we have 5 new forms that relate to the pandemic. Um, so we're going to go over the basic contract and all of the addenda that you could attach. Years ago, there was really just one uniform form for the most part. And I think it goes back maybe within the past 5 or 10 years, uh, the New Jersey Realtor Group, and Barry Goodman is their attorney, who I know worked on and prepared many of these forms, decided that instead of having this very kind of cumbersome longer form, they would do a shorter, it's about a 12-page contract. And then the last paragraph, paragraph 43, has, I think, about 14 or 15 now possible addendum that you could add for specific needs. So if you don't need those addendum, then you can just do the basic form, which is a lot easier to manage with clients and sending around. But when you do need them, they're there. One comment, and I'll mention this more than once, is that if you're going to use the addendum, paragraph 43 has a box that you're supposed to check off. That means it is attached. Sometimes I've gotten contracts in where the box is checked off and there is nothing attached. Other times, there's an addendum attached, but there's nothing checked off in box 43. And it should be consistent. This comes up often when we're dealing with lenders. Lenders see this and they don't like it. If they see the check, they say, where's the form? As an attorney, I feel the same way. If a box is checked in a contract telling me that there's another document that modifies this contract, it needs to be attached, or I don't have a full contract. So, as agents, you guys are preparing a contract which historically, lawyers have done. So they try to make it easy. It's basically fill in the blanks, but there's a lot of things I think they get missed. I get a lot of contracts over every day and I read them. Some folks are excellent at filling them out. Some people cut some corners. Sometimes time is an issue and you just really have to get it done and signed. And that's okay. We can fix things in attorney review. But we're going to go through today as if you had enough time to fill everything out and do it the right way. So I thought about whether I should put these forms online, but the reality is everyone who's listening has access to these forms. These are the standard NJ Realtor forms you get on the zip form once you're logged into NJ Realtor. And this is how most folks prepare their contracts. So I'm going to go through as if you have these at your fingertips, because if you're at a computer, you basically do. And if anybody wants me to send the materials, which is basically just the contract and all the addenda that are attached, you can email me at brad@batchalaw.com, BATCHALAW.com, and I'll email you back a copy of the materials that we're using for today's webinar. And if you want to call us for anything, you can always reach us directly at 732-747-8300. All right, so the first document is the boilerplate contract, and on the front of the contract, there's a notice that's required. So everyone has to fill that out, and it's required by law. And there's a box you have to check. You're just supposed to designate whether you are the seller's broker or the buyer's broker or both or neither. So make sure that that gets done and signed because that's required by law. Then we get to the basic form contract, where we really need to get every bit of information in there. Sometimes it seems like it's not important, but for example, we need the buyer's full names. because this contract ends up getting used to order title, and the mortgage company is going to rely on it, and everyone is pulling information off of here. So when you're preparing the contract, it is important to ask the buyers, what is your full name? What name do you want to be listed on the deed? Because this contract is the beginning point from which everything flows. So if there's a mistake here, it often gets carried over and ends up creating small but problems along the way that could be avoided if it was done properly. Same thing, try to get the buyer's correct address so that that appears, get the town and the zip all correct. And agrees to purchase from the seller. Now, it's always the buyer's typically agent who's filling this out unless you're dual disclosed. So you don't necessarily have all the information for the seller. However, you can get it. You can either ask the listing agent, right within the MLS site, you can go to the Realist site, which takes you to a copy of the county tax records. You can also go to a site called Mod4 New Jersey, and 4 is IV, Roman numeral 4. And there's a great resource there for a tax database. But that information is out there. So a lot of times I'll get contracts and the sellers are blank. There's really no good reason for the seller to be blank. I realize maybe you don't have the seller's name, but there is a tax record which shows who owns this property. And that's actually a good thing because, sometimes the wrong name gets in there. If you pick it up off the tax records come from the deed. And at closing, we need someone to sign a deed just the way it's written. So if you follow the tax records for the seller and the seller's address, and the seller's address isn't always the property address, sometimes it's somewhere else, also will be reflected in the tax records. You should also, of course, put the property address and the municipality. Now, New Jersey is a unique state. We have many, many properties that have a mailing address in one town, but the municipality is a completely different town. Again, the tax records, the Realist site or the Mod4 site are a great resource to understand what property the town is actually in, what municipality it's in, versus just what the mailing address is. You need both. You actually need to put the mailing address in one section, and then the property municipality in another. What I like to do, which I think is the easiest way to fully understand what you're doing, is, for example, there's a lot of towns where I work near Shrewsbury that are located in Middletown Township, and many of them have a mailing address of Red Bank. So what we do is we say it's the Red Bank address and the Red Bank zip code, so it's clear where the mail goes. But in parentheses, right after Red Bank, we write Middletown Township. And then, of course, on this form, there's a place to show the municipality of Middletown Township and the county. And get the block and lot too. That should be pretty readily accessible right on the MLS site, or the Realist site, or the Mod4 site. All right, so moving on, the next section you have to fill out is the purchase price. So that's easy enough. But then they talk about the initial deposit, additional deposit, mortgage, and balance of purchase price. So let's talk about the deposits a little bit. There is a place you can put who holds the deposit. Now, normally, in my practice, it's the seller's attorney that holds the money. Some realtors have put their own company in there. I've noticed a trend that realtors do not want to hold money in their trust account. They don't want to be bothered with it. There used to be a practice of taking the initial $1,000 just as a sign of good faith. Some people used to think you needed that for consideration. You really don't, because people are signing a contract with promises, and that acts as consideration. So taking in the initial $1,000, I think, is probably a waste of time. I defer to you and your broker to make that decision. But chasing that $1,000 around is more trouble than it's typically worth. So whether or not you need to break up an initial and additional deposit, I'll leave to you. My preference is just do one deposit, call it additional or initial, whatever you want to call it, but just do one and have it due within a certain number of days after attorney review. 5 is very common, 7 or 10. Give the buyer a few days to get their accounts in order and get the check to where it needs to go. The other comment I have on deposits is that historically deposits were 10%. When I started practicing, early on in the 80s and 90s, deposits were 10%. That was just the way it went. But more recently, I've found, especially when you're dealing with properties that have a high value over $1 million, it's more customary to go for about 5%. Now, if I'm representing a buyer, my goal always is to get them to put down the smallest deposit possible to make the deal, because I don't want any more of their money at risk than we have to put down. And so some people say, well, why? What does it matter? You get a credit. The problem is, if you have a bad situation where either the buyer does default, or there's a question of whether they defaulted, and we think we're right, or the sellers are just being jerks, but the parties can't agree to release the deposit back to the buyer. So what happens is the money sits in an attorney's account until this gets resolved. I'm not worried that anyone can take it. It's just going to sit there. But that may mean that our buyer can now not go out and buy their next house, because too much of their funds are sitting in this account until this issue gets resolved. So for that reason, I always try to get the smallest deposit possible. The problem I have is when I get a contract over and it's got a 10% deposit or a very high deposit, and then I have to backpedal. And often sellers, psychologically, they don't want to hear that the buyer was going to give $100,000. Now they only want to give 50. So as agents preparing these and advocating for your buyers, I would try to start low and try to get the lowest deposit that the seller will accept. If you have to go up, we have to go up. But it's more difficult for me when I come in and read them my spiel about why you should have a lower deposit, and then I have to go in and play the bad guy and say, well, we really only want to put up 50,000 instead of 100. And by the way, 50,000 is enough of money in this example that the buyer would proceed in good faith. I mean, that's the purpose of a deposit, is for to guarantee the good faith performance of the buyer, so they just won't walk away on a win. All right, so that's enough about that, but please keep that in mind as you're preparing these, because I think, again, psychologically, it sets the tone for what's to come. So the mortgage section, at page 1, there's a place where you put the mortgage, and there's another section on page 2. Make sure those match. You're supposed to put in here the type of mortgage, whether it's a VA, an FHA, a 203K, which is rare, but it's like an FHA for improvements, or a conventional. You're also supposed to put the term of the mortgage. Most commonly, we put 30 years in there, and monthly payments based on a 30-year payout as well as most common. As far as timing, because of this pandemic, sometimes we've been going for closer to 40 days, but the standard in the business is 30 days. And by the way, if you look at this contract, one of the things that Barry did and the NJ Realtors did was they put together these fill in the blanks, but they also added clauses that say if it's left blank, then it's deemed to be X. So in the world of mortgages, if you forget to put in a date when the buyer needs to get their mortgage, the default is it goes to 30 days from attorney review, which is fine. I think that's a fair way to do it. So if that's left blank, I don't have a problem with that. And then, of course, the closing date. That's got to get in there, paragraph 8. And I'm going through all these things because, honestly, I see so many contracts, each day. And again, some of them are filled out wonderfully, and others, there's things missing. Paragraph 6 and 7 are important. These have to do with items that are included or excluded from the sale. So oftentimes, there's typically a multiple listing. And in the listing, there's a section where they talk about which items are included and excluded. So often agents will reference those particular documents. That's okay. You could also cut and paste from the MLS right over to these sections, so it's crystal clear what's intended to be included and excluded. I have seen over the years that MLS get updated and things get changed. So we're better off to put it in a static contract where we all know what we're doing. Also, oftentimes, the person reading the contract doesn't have access to the MLS. I mean, I happen to have access because I've always had a license as a realtor since I became a lawyer, for the sole purpose, really, to check MLS every day and cross-reference my contracts. So when it says, as per MLS, I can log on as an agent and see that. But most attorneys can't do that. So it's a better practice to cut and paste the actual words showing what's included and excluded from MLS rather than referencing it in this section. Certificate of occupancy section. There is a blank, and it says the seller has to get a CO, and the limit is up to 1.5% of the purchase price. Well, that's a big number. If you've read any attorney review letters, normally sellers' attorneys like to limit the obligation of the seller to about $500 or $1,000, maybe 750. But 1.5%. I mean, if that's a $1 million sale, that's $15,000. That's probably more than the seller is willing to put out of pocket to grab a CO. But if you're representing the buyer, I would tend to leave it blank because I'm not looking to limit the seller's obligation. If you have both sides of the deal, you're already in a lot of trouble because that's close to impossible to fill out. They don't allow attorneys to draft contracts when they represent both sides of the deal because there's an inherent conflict of interest. Same conflicts exists if you're an agent when you're filling these forms out. So all I can say is it's tricky. Maybe you just leave things blank and go with the default. I really don't know how to answer that because there's truly no great answer as to how you prepare it when you represent both sides. And you have an opportunity to fill in a blank which favors one side or the other. And the way we solve this conflict is attorney review. Each party can seek out counsel. We can make changes to anything that we have. So, okay. Now I hope people could hear before, but I just changed one setting and all right, so moving on. We are at page 5 of the realtor contract. When it comes to quality of title, that's just where you have to put in whether it's a single family home or not. And then we have paragraph 12 where, and again, this stuff gets missed sometimes, but you need to put in if there's tenancies. And if there are tenants, there's a section where you actually are supposed to list the tenant's name and the rent and the security deposit. Very important stuff. Obviously, as a buyer's agent, you don't necessarily have this, but that's something you probably should have before you even sign up a contract, is to know who the tenants are, what they're paying per month, because that's a critical aspect of the deal. If it's a tenant that's going to be evicted or removed prior to closing, I would still list them in there so that all parties are aware, or at least put in paragraph 43 or 44 at the end that the tenancy will end prior to closing. Lead-based paint, you need to put whether that's applicable, whether it's pre or post 1978. And then they have point of entry systems. Again, just check these boxes off. Most of the time they don't apply, but sometimes they do. Of course, there's one for septic as well. So, if that is applicable, there's a special addendum we're going to add to that too. All right, so moving on into the inspection clause. Again, what they put in the basic form is that the default is 14 days. So that's fine. If you want less than 14 days or more than 14 days, usually, again, you're filling this out representing a buyer, you want to expand these unless there's some pre-agreement that it has to be tightened up, and then you can tighten it up in there. But normally, we'd like to give the buyer as much time as possible to make sure they get their inspections done and they don't waive any rights vis-a-vis inspections. All right. There's a couple sections within the inspection clause where you are supposed to fill in dates. So just, again, make sure those get filled in properly. Moving further on to paragraph 29 and 30, this has to do with all of the information for the real estate agents. So this is really important too. One of the things that we have to do as lawyers is do an attorney review letter. Fortunately, a couple years ago, we had the law modified and we only have to send emails out now. So it's more important than ever that paragraph 30 get filled out properly, because that's the section where we are designating the realtor's email addresses. So everything really needs to get filled out in that section. The listing firm, the listing agent, the address. There is on MLS site a database called Office and Agents up, and you can click on it and you can go through and look up all the information you need for any agent. So whether or not it's listed properly. It should be right in the MLS as well. But if for any reason it's not, you got to grab their email address, and it's got to make its way onto this form, because that is the information that the lawyer is going to use when they send out the attorney review letter. So if that's not accurate, if it's off by one letter, then that agent is not going to get the required notice that they have to be sent under attorney review. So very critical that that section is paid careful attention to. Section 32 has to do with whether or not you have an ownership interest in the property as a licensee. So if the buyer or seller is you, you need to fill out that section so that it's clear to everybody, as required by the Realtors regulations, that you are a party and also a licensed agent. All right, so it's paragraph 42. I might have said 43 before, but paragraph 42 is the one that tells which addenda are attached. So they have, let's see, 1, 2, 3, 4, 5, 6, 7. They have 14 different addenda for this particular contract. There's actually other riders that they mention, but they maybe don't relate directly to the contract. We're going to go through all of them today and talk about when each one is applicable and how to fill them out. But again, make sure if you're going to use one, you're going to click off the box in 42 indicating that it's attached. That way, when I get a contract and I don't see anything attached, but I see paragraph 42 says, oh, there's a seller concession attached, I know to say to the agents involved, where's the seller concession form? It's noted in 42, it's attached, but it didn't make it to me. I don't know if that's a way that DocuSign works or somehow, but often these addenda get detached from the main contract. Whether or not that's intentional or there's some systemic issue with it, it does happen. So filling out this 42 paragraph properly can avoid a lot of problems, because if we know they exist, at least we can try to track them down. The wire fraud notice automatically prints itself. It's critical. One of the first things I do when I speak to a client, even just for doing an attorney review, is I say, there's going to come a time where you are going to need to wire me money. And you need to verify verbally with us, with someone that you know in our office at this number that you're accustomed to calling, what our wire instructions are. Sometimes even on day one, I give them the wire information and we verify it, because it's so critical. There are so many fraudsters out there that are intentionally targeting our industry and trying to trip somebody up, and they will go after agents. They will go after anybody. And the entire goal of this is to trick a buyer or a attorney or title company into wiring the funds to the wrong account. So make sure that is a great form to have. Make sure everybody signs it. We can't stress enough that it's critical before anyone wires money out to double, triple check that they're sending it to the correct account. Okay, so the first of the 14 plus forms that we're going to go through is the buyer's property sale contingency. So a lot of times I'll see in paragraph 43. 43 is like the throwaway one where you can add any additional information that you want to add. And in paragraph 43, sometimes people will put in there that the property is contingent on the sale of the buyer's property. That's fine, but I think it's probably better if you check the box off that says buyer's property sale contingency, and then you fill out the addendum. This is a pretty good addendum for a buyer. It does allow a seller to continue to show the house prior to the buyer getting a contract. But once a buyer has a contract, then they have to stop showing the house. So it's not too bad. Take a look at it. Again, reading these, I know can be cumbersome, but it is a good idea if you're going to be using these addendum to realize, and understand what they say. Most of them aren't that long. And if you have any questions on them, feel free to reach out in the preparation stages, and we're happy to help you out answering these questions and deciding what to put in the blank. The only real fill in the blank is that on this form is what property is being sold and how long the buyer has to get a contract. And if they don't get a contract by that particular date, then this could be deemed null and void. So important addendum, use that when necessary. The same thing, let's see, the second addendum is the condominium or homeowner association addendum. And this is great. I'm glad they put this in because this is something, whenever there's a condo, we always put a similar clause in our attorney review letters. Once you know your client is buying a condo, make sure you get as much information as you can. Obviously, you're going to want to know what the monthly fees are. You're going to want to know what the upfront fees are. It's also really important to find out if there are any pending assessments and to find out if there's any litigation that the association is involved in. Um, if you're on the listing side, it's really great if you can gather all that information before you even post your listing. And that means getting a copy of the budget for the current year, getting a copy of the bylaws, getting the rules and regulations, master deed. You know, years ago, and this still happens sometimes, you were burdened with this big, heavy book of a public offering statement, which included all those documents. More and more associations now are making these documents readily available electronically with just the push of a button or the click on a link. That's the way it should be. I know there's some still out there that want you to pay $200 and they give you a book, or they make the seller give it over. But these are really important information because unless the buyer can read the rules and regulations, they don't know if they can bring their 35-pound dog, or 3 cats, or where their family members can park. All these things are built into these rules and regulations. There's some associations out there that are not really in good financial shape, and that would be discoverable if we had a copy of the budget and financials. When there's a mortgage company involved, they will inevitably require this information and a condo questionnaire, and they will essentially vet out the association to make sure they're in reasonably good financial condition. What they won't do is they don't care about their rules and regulations about what pets you can have or where you can park, because that doesn't impact the value from a lender's perspective, but it may make a critical difference to your buyer. So again, as a listing agent, you can get all that stuff in the document section. I love the document section in the MLS. So when you go onto a listing and you click over the documents and they have all this great information there, a copy of the survey, the title, it just makes me very happy because I don't have to track down the other attorney and put provisions and contingencies in there that I want to see this stuff first. I can just read it, advise my client, and it's out of the way. And that's really what you want to do as an agent. If you can get all that stuff up front and we can learn about it on day one, when people are excited to buy, not later they find out some little problem with the survey, but on day one, we get all that stuff right to everybody, whether it's the condo stuff or dock stuff if you're on the water. But getting all that together, assembling it and posting it online, it just makes the transaction so much easier. So that's what I suggest with the condo stuff. The next one on the list is the coronavirus addendum. So this was put out, I think it was March 20th, and it basically addressed the fear that everybody had that we're going to sign a contract, but yet we're in a state of emergency, and so many services are shut down that we're not going to be able to move at the same speed that we traditionally had moved at, whether it is getting our mortgage on time, getting inspectors out there, where it's an actual physical move that we have to structure with the movers. So there are so many unforeseen problems that we were facing. They came up with this addendum. I do not like the addendum. It to me is too broad. If you read it, it says things like, if it's not possible because of unforeseen circumstances, including, and then they list a litany of different problems they could have, then both parties agree to adjourn it for 30 days. That I'm okay with. But then it says, after which either buyer or seller can cancel. So it kind of takes the teeth out of the entire contract, because now we're dealing with this gray area where, well, what was the delay for? How do you prove if it was directly related to COVID-19? It seems like everything is somehow related to COVID-19 right now. So I really don't like it. There's even a box you can check off that says, if anything changes in the buyer income and then they don't want to buy, they can cancel. it's just too wishy-washy. I am all for putting in a provision that says if there's a reasonable delay, everyone will honor the delay. But if I'm a buyer, I don't want the seller to just be able to say, look, I just don't want to move. I'm nervous about this or that. Or, even if a family member was ill, it seems like this contract would get you out of this addendum rather would get you out of the contract. So I don't like it for that reason. I'd rather limit it to we're all agreeable to a delay up to 30 days for good cause, but not that they can ultimately just cancel the contract. All right, the next one is the FHA VA addendum. If you do have a client who's going to be using an FHA or a VA mortgage, there's a couple things to keep in mind. One, there's a special appraisal that needs to take place, and unlike the standard appraisers when you're doing a conventional loan, those guys are really just looking for value. But the FHA and VA appraisers, they're of course looking for value, but they have a little list that's produced by the FHA or VA, and it's a list of items that have to be a certain way in a home. And if they aren't, they condition the appraisal on the seller correcting or fixing or upgrading those items. And I've seen anything from, they got to paint the side of the house. So this particular clause is required to be signed by both parties. And it just says that, if the house doesn't appraise or if there's a condition that they won't satisfy, the buyer doesn't have to go through with the deal. It might be repetitive because you have a mortgage contingency clause, but nevertheless, it's required by FHA to get signed. So if you get this signed up front by everybody, you might save yourself a little bit of a hassle when the mortgage company sends you the clause and says, oh, you have to have this clause signed. You're one step ahead. So the next one is the new construction clause. So most of the time when you're dealing with new construction, you're going to have a builder. And the builder, most of the time, again, has prepared a very detailed long-form contract that addresses all aspects of the new construction, which is so much different than the boilerplate broker contract, especially when the house hasn't been built or is partially built, because there are all kinds of things we have to worry about. First and foremost, when will they ultimately finish the house? We also have to be concerned about, upgrades and color selections and substitution of materials. It does say that, they'll give a state warranty. This isn't a bad addendum when you come across a situation where the builder does not have their own proprietary form. So if you're in a new construction deal, I would recommend using it and then pass it off to the lawyers, and the lawyers will tweak it out, because not every clause in there is perfect, but you're much more ahead of the curve than you are by using a standard broker form contract to do a new construction deal. Okay, the next one is for septic. So this particular form, it gives you the right to either say the buyer is waiving the right to investigate the septic or is exercising the right. Unless you have a deal where the septic is shot and it's priced accordingly, you really never want to waive your right to investigate the septic. If it's brand new, maybe, and you have a certification, but for the most part, you got to do your own test. And the reason is because the septic system is, far and away the most expensive system in the home. It costs anywhere from $30,000 to $50,000 or more to replace the septic system. They're just very costly. So critical form, if you do have a home with a septic system, again, this is a good way to start. Check it off that it's in there, alert all the parties, because again, an attorney reading this form is not going to know whether it has septic or not unless you add the septic addendum and you click off in box 42 that it's attached. Unless they maybe have access to MLS, which again, most lawyers do not. So it's a very important form because there's special provisions you want. You want the buyer to really have a broad latitude to test the septic. Some of these septic inspectors will come in and they'll say pass fail, and often they'll pass someone and they'll write in the report, look, you got to replace the system in a year or so, it's technically passing. And now you have a buyer who's maybe just barely getting to closing with a potential $30,000 plus bill coming in the next year or two to replace the septic. So, it's really important that this be brought to the attention, and this is a great way to do it. And this isn't a bad form. I usually would probably expand on it, but it's a good place to start. By the way, as we're going through this, and we're a little over halfway done, there is a part, and one of the reasons you guys are doing this live is you can ask questions. So I have a little chat thing. No one really asked me any questions yet. I have a couple comments, but feel free to ask any question as we're going along, and I will either answer it in real time if I see it, or certainly before we end the session, we will go through any questions that are out there and address those. If you have any friends who wanted to hear this, or you think this was a good webinar and you'd like to listen to it again, it will be up on my website at bachelorlaw.com. We have a YouTube channel, which if you click on that, it takes you to all the webinars we've been doing, so you can rewatch them. And I also have a podcast. So if you click on go to my website, you can click on the little iTunes logo, and that will take you to our podcast. And you can listen to all of the webinars that we've been doing. All right, so the next one is private well testing. So there was a law passed, it's got to be going back 20 years, that said whenever there's a well on a residential property, the well has to be tested prior to a closing. It's interesting, the law did not say who has to pay for that test, but the custom and practice has been that the sellers pay for the test. I don't know if that's because that's what the boilerplate broker's contract says, or some towns that require a CO mandate that you have a well test. So for whatever reason, that is part of the custom and practice that we're dealing with. This form for the well testing does say, that they have to meet these parameters, and then it gives the buyer the right, if they didn't meet these parameters, to cancel unless the seller is going to address them. So it's not a bad form. Again, if you have a well, please use it. It brings to everyone's attention that there is a well. Click off the box in number 42, indicating that there's going to be a well addendum. Very short addendum called properties with 3 or more units. Again, this is important when you're dealing with any structure that has 3 or more residential units, because those are governed by the Department of Community Affairs. So you have to get, besides getting a CO, you have to make sure that the owner of that property is up to date on all of their state inspections. They call them a green card, because they were always, I guess, a green card that they would fill out. You have to kind of hang it in the building. But they're required every 5 years on what these are called multiple dwelling acts, multiple dwellings. So if you have a multiple dwelling, it's subject to the Hotel Multiple Dwelling Health and Safety Act. You have to get these every 5 years. And this just, again, indicates that this is required by the seller, and they represent that they're compliant. Seller's concession. This is a good form too, because sometimes when this gets written up in the contract, it's not the exact language that lenders require. So this is a nice little addendum. All you have to do is put in the blank of how much the seller's concession is going to be. Just a comment on seller's concession. There was an ethics ruling a number of years ago, and lenders honor this too, that you cannot have a seller concession that exceeds the actual closing costs. So what that means is when you're filling this form out, you have to try to anticipate what the buyer's closing costs are going to be. It's not that easy to do, but if you were to call my office, call maybe the mortgage company, they may know. We can kind of ballpark it just because we've done so many. But between the title insurance, the survey, the legal, the escrows, the bank fees, all those fees, they basically work on a sliding scale depending on how much the home costs and how much the taxes are in the town. So we want to pick a number that we know will be at least the amount of the closing costs. So, if we think the closing cost might be 12 or 13,000, maybe we pick 10, because what we don't want to do is go over that number, because it creates a problem where the buyer can no longer get that credit, and then we have to decide how we work out something with the seller and the lender to make this work. So please use the form. the reason that the seller's concession form is helpful because it allows the borrower the buyer rather, to borrow a little bit more money, assuming the house appraises for more. We can artificially increase the cost of the house, and then we can give back that increase by way of a seller's concession. So the seller nets the same amount of money, but it allows the mortgage company, if it appraises, to be able to lend more. All right, look, I got a question, which might as well tackle now. The question was, if you have 3 or more units in a state inspection, does it need to be redone at the time of sale, or does it continue as the 5-year time frame? Good question, and it does not need to be done at the time of sale. You just have to prove that they're current. And at the next 5-year mark, it's got to be done again. So it's not a requirement like a CO that's required for the actual sale, but we have to make sure that they're up to date on their inspections. All right, the next one is addendum for possible short sales. And that's obviously important. You know, one of the sections you have to fill in here are the lien holders. You know, we don't do as many short sales anymore, and that's a good sign for the economy because there's less of them out there. But there was a time where we had many short sales, and they're tricky. They're trickier when there are multiple lien holders. So this has you list each lien holder and the amount. If you're going to be buying a short sale, you're going to have a really good dialogue with the listing agent and find out what they're up against. If you don't know, we can do a little mini title search. I can look in the, make sure it's not under foreclosure. So you might want to give a call before you're filling this out because there's important information that you really need to know in there before you get under contract. I can tell you, if you have one lender and they're not yet in foreclosure, we might have a pretty good chance of getting a short sale approved. If they're up against a sheriff's sale, the lender has a lot less incentive to agree to a short sale because they can take the property through a sheriff's sale very easily in the next, possibly few weeks or a month. So knowing that information is critical, and also knowing if there's more than one lender is critical. Much easier to get one approved than 2 if they're both going to be short. And then there's a section where you're supposed to fill in the deadline for how long. And, if I'm representing a seller, I always want 60 to 90 days. Buyers usually are willing to go along with that. They're going to have to take a few lumps if they're going to get a deal, which hopefully they're getting a discounted price on a short sale. The next one we're going to talk about is the solar panel addendum. This was something that was only added October of 2019. It's very wise to have this form. Whenever I see solar panels, red flags should go up. If you're walking around the property and you see a solar panel, you better figure out what is going on because a lot of these solar leases are terrible, unfortunately. Now, some of them are fine. I did one that we're going to be closing next week where the owner had prepaid everything and we got a transfer and my clients don't owe anything and they get all the benefits of the solar. But some of them are terrible. And we really need to make, as a contingency of a contract, our ability to review the solar panels. One of the problems is sometimes we don't know. I mean, I put in all of my addendums now that the seller represents there are no solar panels on the property. And if there are, then at least they tell us in attorney review, and we could create a contingency where they give us the solar panel lease or finance agreement, or they represent that they're owned outright, and we can analyze whether it's a good deal. Because some folks get in there and they're faced with either paying a certain amount per month, or the company wants to come in and charge you a fee to take them off, and sometimes the property gets damaged in the meantime. There are a lot of potential pitfalls when you're dealing with solar panels. But they can be okay. It's just that it's such an important part of a real estate deal that sometimes gets missed. So I'm glad that the NJ Realtors decided to add this as a part of their contract so that if there's a solar panel, you have to decide, is it owned, is it leased? There's a lot of questions. These are tricky to fill out. I'd recommend consulting with an attorney even as you're filling them out, or at least getting the information from the seller's agent who's carefully reviewed this with their attorney and their side, because it's quite a complicated form. I don't think I need to go into all the details of it today, but effectively they need to know who owns these panels. Are they leased? Are they owned? And if they're owned, are they financed? And then what is the monthly payment and how long does that go? We also sometimes like to look and see the actual bills from the utility companies over the past year or two to see how this solar panel has been benefiting the property, whether it's resulting in very low monthly utility bills, or if they're entitled to certain SRECs where they're selling these, and they're able to, get money back from that. So they can be great. I know, very environmentally friendly, but they're also quite a nightmare when you're dealing with like a 30-page solar lease that has to be read. One of the other new ones that they put in just last year was an addendum regarding swimming pools. And this is important too, because the standard form contract doesn't really address the pool inspection, and it's an important part of a purchase. There's always a separate pool inspection. They have a place here to list the accessories that are included. Whenever you're doing whenever you have a buyer and they're buying a house with a pool, you always want to put in your inclusions all pool equipment, because often it's not listed in the MLS and it's not included. And then you have sellers maybe who are going to a newer house with a pool and they take their stuff with them. So it really needs to be listed that all pool equipment is included. And there's a place on this form to do that. And it just, again, alerts everyone there is a pool inspection. If we're in the winter, we might need to see who serviced it last. We should probably try to get the name of the pool company and deal with that. So again, I'm glad they added this because this is an important part of the contract. The last addenda that relates specifically to the contract, because there's about 3 or 4 others we're going to go through, is the underground fuel tank one. So I kind of think you should do this addendum on every single deal, because there's a place in box 1 where the seller just gives their representation as to the history of tanks. And box 1 says there are no tanks. Well, okay, if there's no tanks, that's great to know. Or 2, there is a tank that's being used, or there was a tank, but we removed it on this day, either by us or by a prior owner, or a tank was abandoned in place. I hate those the most, because that means the seller saved $200 or $300. I mean, there are situations where it makes sense if it's like in the foundation, but most of the time they just save a little bit of money and get it filled with sand instead of actually excavating and taking it away. And now they are burdened, and all future owners are burdened with this eternal obligation to disclose that there's a tank in the ground when they could have just taken it out and not have to say this each time. So when I come across this, I typically always ask that the seller remove the tank. And if the seller refuses, then I ask, can the buyer remove it at the buyer's cost? Because it has happened where we've had tanks that were, quote, abandoned in place that ended up leaking. And if that's going to happen, we need to make sure that we discover that while the seller is still the owner of the property and not after a closing when a buyer takes over. And by the way, the buyer doesn't want to have to go sell it someday and say, oh, well, yeah, I know my seller told me when I bought there's an abandoned tank in the ground. Well, is it leaking? I don't know. Take it out. And then when they take it out, they might discover there's some kind of a problem. So it makes sense walking in the door to insist that the seller do this and not have to worry about it as a buyer. So anyway, this form goes through that nice analysis, and then it gives obviously the buyer the right to do a test and do a scan and require the seller to address these kind of issues. So the lawyers will end up reading these, but it's a great if you can make sure if there's a tank. Honestly, like I said at the beginning, any file, great to use this on. Maybe it's brand new construction and a new development, you don't use it, but almost anything can potentially have a tank, and we need to know what the sellers are going to say about it. When it comes to me, it's in every one of my review letters. Seller represents there are no tanks, there's been no history of spills, there's no tanks taken out, and they give us a copy of any documents relating to the removal or closure of any tanks. But this document is pretty good because it begins to flesh out that process. All right, so the additional addendum I'm going to go over, they're not actually addendum, I guess, to the contract, but they're additional forms that have been promulgated by NJ Realtors that are really important, and these relate to COVID-19. So we talked about the one already that was an addendum to the contract, but this one is a hold harmless and release. Now, this was actually just updated on June 12th to change some of the language because things have changed since they first drafted it. But it's a good form. I would imagine all of your all of your brokers want the agents to use this form. And this is not a form that you sign when you get a buyer to do the contract. This is a form you have to sign before you even show a property. It's to release you from liability, God forbid, that somebody goes in and gets sick, gets coronavirus from being in a house, or maybe they didn't even get sick from that, but maybe they accuse you as the agent of, putting them at risk in some capacity, whether it's the buyer or the seller. And you really have to work it out with the seller and the buyer. Everyone can agree to a list of protocols, that there were gloves, there were masks, the seller shouldn't be present at the time. But it's got a strange representation in here, and just make sure you read it and not just sign it. It says, you are representing as buyer and seller that either you or your family members or your agent or inspector have not tested positive or showed signs of COVID-19 or been in contact with anybody in the past 14 days who tested positive or is waiting for a test result. This is a very broad language that they're using, and I'm not sure that many people can sign off on this. But it's good because the last paragraph says that the buyer and the seller agree to absolve and hold harmless the broker, which is really what we're trying to make sure happens, that no one's going to come after you guys. So someone just asked, should the buyers and sellers entering your office sign this? Good question. That's not what this is intended for, but it seems like it would cover it. It's really particularly addressed towards visiting the property. So it doesn't mention visiting the realtor's office. There might be a similar form you sign, or if you have them sign this, I guess you could argue that they understood they were taking risks by going in any property. But the purpose of the form is prior to a showing of a property. There's a very similar form for landlords and tenants, same concept, it's just a different form. The first one identifies buyers and sellers, the second one identifies landlords and tenants. So they also mention in these forms the virtues and the benefits of doing a virtual showing of the property. And we all know that there's pros and cons there. So there's another form called the release of a buyer or tenant who is being shown a property virtually. And in that form, it goes through and talks about the shortcomings of only seeing a home virtually and not being able to physically be there. It's kind of the opposite of the other form, but it's to protect the realtors, to say, like, look, you're buying this house kind of sight unseen to some extent, and you've only seen it using a video, and you're okay with that, and you're at peace with that, and you're going to release us as the agents from not, telling you about some aspect of the house that maybe we didn't know and you didn't see prior to you being able to sign this. So if you're going to do a virtual sale, and I've done them before, in fact, before the pandemic even started, I had a handful of them. One I'll never forget. It was like $1.5 million home, and it was these millennials I spoke to, nice people in the city, and they're like, "Oh yeah, well, we don't have time to see it. We looked at the video, it looks good, we'll take it." Look, everyone has their own standards of how they want to buy and sell things. It doesn't, seem normal to most of us who have been doing this for years or making that large of an investment. But this form kind of protects you as the agent from a lawsuit, potentially from a buyer or a tenant who says, I bought this, but I didn't know this, and you should have told me this. Well, maybe the agent hasn't seen it either for the same reasons that the seller doesn't want to let folks in the home, or they're not permitting showings. So when you're doing the virtual, you can use that form. And they also have, and this is a strange one too, but this is the seasonal lease addendum. Not in love with this one either, because it gives prospective tenants the right to kind of cancel or walk away from a binding lease, that a lease that's otherwise binding. And it's just too flowery language. It's not tight enough. It says that if there's unforeseen circumstances where that the lease is frustrated, impossible, or impractical. So, beaches are pretty much open now, but if a beach was not open that was a few blocks away, does that make it impossible to rent the house? No. Does it frustrate that particular buyer's purpose? Maybe. But what it does is it lets you out of the lease as long as you give notice 30 days before the lease starts. So it's kind of arbitrary, if you ask me, and I'm not in love with this form. Defer to your broker if you want to use this, or your client if they want to use this. I guess it helps some buyers get out of deals if you're representing a buyer or a tenant, rather. So it helps on that. But if I was on the other side of this, I would, as a landlord, I would not want to agree to anything like this because it really takes all the teeth out of my lease. Much like the coronavirus form that is attached to the boilerplate contract kind of takes all the teeth out of the contract itself. I'm not a big fan of that one. All right, so that is pretty much all of the addendum that we need to go over today. It's just about 1 o'clock, so we like to do these for about 1 hour, so we're getting very close to that. But we still have an opportunity. We have a few more minutes to take any questions. If anyone has any questions that we didn't get answered, I think I answered the ones that I noticed so far. But we can otherwise kind of wind this down. If you need to reach me, please give us a call, 732-747-8300. If you want any materials we went over today, you pretty much can find them on your MLS, but I can email you the whole packet. If you want to send me an email, it's Brad, B-R-A-D, at batchalaw.com, BATCHALAW.com. And we will get back to you with a copy of the materials. So I'm looking. I don't see any additional questions, but feel free to write them for the next minute or two while we wrap this up. So, thanks everyone for logging in, and good luck with all your showings. I know it's a kind of a trying time. We've been working every day. We're still doing mortgage closings. We have folks come in, even though they passed this Remote Notarization Act, the lenders aren't quite on board with doing a remote closing for when there is a mortgage involved. So otherwise, all the cash deals are very seamless. We don't have anyone come to the office, but for the mortgage, we have a separate room where the buyers sit, sign their mortgage. Once they're done, we come in and grab everything, notarize it, and ship it off to the bank and get a closing done. So happy to help out with any of your needs. Just reach out, and thanks for logging in. And remember, let your friends know if they missed this and you think this is a good webinar. You can check out our webpage, batchalaw.com, and click on the YouTube channel or the iTunes. You can go to iTunes and just search for our podcast and listen to the podcast at your leisure. So thanks again. Have a great day.